Hello everyone, and welcome to today's webinar, 2019 LMS Board Member Bootcamp. My name is Jackie Abraham. I'm a Regional Director for Lieberman Management Services. On behalf of LMS, I'd like to thank you for dedicating your time to join us for today's training session. The webinar will be about an hour long and covers important matters related to your service as a board member. We hope the session will be of value to both new and veteran members. I am pleased to introduce today's speakers, Kat Formeller and Kathy Chulakas-Heitkamper of Tressler LLP. Kat is the lead attorney for Tressler's Condominium and Common Interest Community Association practice group. Her practice includes representing communities in a variety of areas, including rule enforcement, interpretation of governing documents, review and negotiation of contracts, and collection of assessments under various laws. Kathy is a partner in Tressler's Condominium and Common Interest Community Association practice group. Her practice includes extensive experience and deep knowledge of all areas of civil litigation, collections, bankruptcy and foreclosures, including a knowledge of those laws pertaining to associations. She is a huge proponent of educating board members and property managers on the intricacies of residing in and managing associations. Before I hand the mic over to our speakers, I have a few housekeeping items to cover about this presentation and the webinar platform. First, today's webinar will be available after the live session on our website, liebermanmanagement.com. Next, we'd love to hear from you during today's presentation. If you have a question for our speakers, please feel free to send it directly through your webinar screen or by tweeting us at #LMSBootcamp. During the presentation, you can send your questions to the host by using the chat function. We'll be answering questions at the end of the session. If we don't get to your question during today's webinar, we will follow up afterward. Please note, attendees will be muted during the presentation. So without any further ado, I'd like to kick things off by welcoming our speakers, Kat Formeller and Kathy Chulakas-Heitkamper. Kat and Kathy, over to you.
Thank you very much, Jackie. This is Kathy speaking at the moment, and Kat is sitting to my left, so she will be speaking. We'll be doing it interchangeably, so just bear with us. We are trying to cover a lot of material during the 60 minutes that we have, and again, as Jackie said, you will have the presentation fully available to you afterwards, so feel free to review the slides because there's going to be a lot more detailed information on the slides than we will actually be speaking about. All right, so in Illinois, we have many types of associations. In particular, we deal with condominium associations, common interest community associations, and cooperatives. Condominium associations, traditionally, you determine that because they are have a recorded declaration, and the recorded declaration provides that it's being submitted to the Condominium Property Act. Generally, it denotes the word condominium in its corporate name, and also you'll also see that it's also been incorporated under the General Not-for-Profit Act. Common Interest Community Associations are also an Illinois association, and those typically are all associations that are not condominium associations will traditionally fall under a Common Interest Community Association. You are not automatically subject to what we call CICA, which is the Common Interest Community Association Act. There are some parameters that require you to be governed under that particular statute. Cooperatives are different. Those are not traditional condominium or homeowners associations. Those are buildings where the corporation holds title to the entire property and the occupants own shares of stock. So you actually have a unit, but you own shares as opposed to holding an actual warranty deed to the property. All right. The board. All right, so we know that an association is governed by their board. Board members must be prepared to govern their respective communities, and the way that that is done is by knowing and understanding your governing documents, understanding the laws that are applicable in Illinois, and knowing and understanding your community's needs. There are several types of governing documents that each association may or may not have. Most associations will have, all associations will have a declaration. It will be recorded. Some associations will also have bylaws that are recorded with that declaration. And all associations should have articles of incorporation, but there are a few that have not been incorporated with the state. So they may not have those. It's a simple process to be taken care of, but that is traditionally the starting point for incorporating an association is by having articles of incorporation. Our primary source will be state law, and then we defer to our declaration, bylaws, articles, and then lastly we look at rules and regulations, and if you're a co-op we look at your proprietary lease.
And what's important about knowing the kind of the structure of your governing documents is if there's a conflict, for example, if you have a declaration that has a provision that in some way conflicts with Illinois law, whether that be Illinois case law, it be the Condominium Property Act or the Non-for-Profit Act, that provision would be automatically moot and void. Because it would be in violation. So you have to know kind of where the steps stand. So your primary would be Illinois law. That's always going to trump any conflict that you would find in your declaration, bylaws, articles of incorporation, also rules and regulations and proprietary lease. And that same would apply at the next level. So for example, if a board promulgates rules and regulations that conflict with provision in the declaration, most commonly you would find this, for example, in a leasing provision. So if a declaration provides that you are allowed to lease units and a board decides to issue a rule and regulation that says you cannot, you have a conflict in a rule with your declaration, and that rule would not be something that can be enforced. So you would have to amend the declaration to allow such a thing. So that's why it's important to just know the level that you're working with and when there could be a conflict.
And of course, always consult legal counsel when interpreting or amending the governing documents, just to make sure that everyone's on the same page with them. All right, the next couple of slides have a lot of information contained within them. We really wanted to point out the differences between a declaration and a rule and reg, and how they differ sometimes, you know, whether they're prepared by the developer, prepared by the board, how they're effective. So a lot of this information is self-explanatory, so please feel free to read through the slides afterwards. We are not going to discuss them in detail here. We've got some qualifications for the board under the Illinois Condominium Property Act. Board member qualifications, you have to be a unit owner, and you are elected by the membership. We define the number of board members, board terms. Again, you guys can see that all on the slide. If you are in a cooperative, that also has different qualifications for being on the board, the types of terms, and the number of board members. All right, so the most important thing that we deal with, probably on a daily basis, is fiduciary duties and making sure that all of our clients are acting in an appropriate manner. So as a fiduciary, you have a duty to act for and on behalf of the best interests of the community as a whole. And sometimes that's hard to keep straight with what we're dealing with. We know that they're your neighbors, but again, you need to, take a step back and remember that you have to act on behalf of everyone and what's in the best interest of everyone, maybe not just necessarily an individual who's brought forth a complaint.
And that's something common we deal with. I'm sure as a board, you guys often have board meetings where you have very few in attendance. You kind of see the same people over and over again. However, there may be one particular issue that could bring a crowd in, and that could kind of make the board feel like they have to act in a specific way in response to a specific issue. And we sometimes forget as board members that that's just one or maybe a group of people of an entire whole that is much larger than that. And so you have to remember as a board member that you're not acting for that group. You have to consider the entire association as a whole. So that's where it can get muddy as far as what is in the best interest, and not necessarily always responding to some small scuffle that may seem larger than it really is.
Yeah, and keeping in mind loyalty and care to the association as a whole.
Another point that just quickly to point out is conflicts of interest. This kind of comes up more so if a board member has an issue that, for example, if they want to contract with one of their companies, they want to hire one of their companies for the association, or a particular board member has an issue himself or herself with the association, remember to always disclose that, and maybe you might even need to remove yourself from a discussion if there's a conflict of interest.
All right, we've also defined in the presentation the types of duties of each of the officers of the board. So, and this does come up often. A lot of board members believe that, or actually I guess a lot of owners believe that they elect the president, secretary, vice president, treasurer, and actually what happens is the membership elects the board as a whole, and then once the board is elected, they then select the officers. So there is a distinction between officers and board members. You are a board member and an officer if that is the role that you have been selected to take on. So we've defined each of the roles. The main thing that the president does is they preside over the meeting of the board and the members. And they really act as the primary liaison between the board, management, the attorney, and other third parties. So it's an important role. The treasurer's role, again, serves as a liaison for auditors and accountants, primarily deals with all the financials dealing with the association. And the secretary. The secretary's role is extremely important. They do, assuming that this has not been delegated to somebody else, they will be responsible for recording the meeting minutes and maintaining association records. They will attest to signatures on legal documents. If you have a declaration amendment, the secretary will be the one certifying it before it goes off to be recorded.
And just note that there are other types of board members. For example, there may be a vice president, and those are not necessarily defined, and they may be more defined in your governing documents, or maybe just something the board defines on its own. And the reason why we covered president, secretary, and treasurer are because those are the three roles that are required under Illinois law and are specifically kind of set forth in the Illinois Condominium Property Act.
All right, there are two types of meetings, ownership meetings and board meetings. Board meetings are by far the most traditional meeting that occurs for an association, while ownership meetings typically are the annual meeting for most associations. An election occurs. Ownership meetings also entail special meetings that may be called for a particular purpose. There was a petition that was filed by a certain percentage of the owners, or there's a particular issue that needs to be addressed. For instance, in a condo association, you may have rules and regulations that are being promulgated by the board to the membership. There will be an ownership meeting set up to discuss those rules and regulations before the board adopts them. So those are the traditional meetings. So when should meetings be held? Under the Illinois Condominium Property Act, we do not have an actual specific requirement for when and how those meetings should be held. We do know that the Condominium Property Act does say that there has to be a minimum of 4 meetings per year, but your governing documents may provide specific dates and times. So that will actually control in those instances versus the statute.
And one thing to point out about meetings is, specifically when we're talking about board meetings, and we'll get into this in a few minutes, is board meetings are a time for the board to conduct business. And I at least in my experience, I've heard a lot of owners say, well, you know, you hold your board meetings at times that are not conducive to my schedule, and it's actually not the case. The board doesn't necessarily need to hold their meetings when owners are available. The board needs to meet when the board can meet, and the only requirement is that it be open to owners. Whether or not they can attend is something very different. And we know that board members typically have other obligations. They may have a job, they may have families, and they should take advantage of the fact that technology makes it much more flexible for them to hold meetings maybe during the day when it makes more sense for them to be able to conduct their business.
All right, so we've got, so membership meetings. I've outlined several different requirements. We've talked about notice. It's no less than 10 days and no more than 30 days prior to the meeting. This is in a both condo and common interest community. Special meetings, you will need to look at your governing documents to make sure that those don't have a different provision, but in the event that your governing documents are silent, special meetings are called by 20% of the owners, or they may be called by the president or the board. And then we've also outlined quorum requirements.
And one thing to note with special meetings, at least in our experience, we've come across this pretty often, is that there is nothing in Illinois law that defines the time period in which a special meeting must be called. So for example, if the board receives a petition from the owners to hold a meeting, there is no requirement that meeting be held within a specific number of days. We've also found that many governing documents, the declaration, the bylaws, are completely silent on the timing of when these meetings need to be held. So it's been our recommendation that it just be within a reasonable time frame. So typically you're looking between 30 to 60 days from the date of the petition, but really no other guidelines other than that.
Yeah, and really it's up to the board to call that meeting. A lot of owners believe that when they put forth that petition, that they get to control the date, time, how that meeting occurs, and that's not the intent behind it. It's not how the law was set up, and that's not the board's. The board does not need to follow that direction, so please keep that in mind. All right, membership and annual meetings. Most membership meetings, as we talked about earlier, handle traditionally, it's one meeting per year, and then there can be other purposes for those meetings. Under the Condominium Property Act, it discusses merger, sale, consolidation, which has actually come up several times this past year. It's a growing trend. And also, we talked about earlier discussing proposed rules and regulations, where the owners get together and get to actually discuss that. All right, so under membership meetings, we also have a basis for voting. Under condos, you're going to vote based on the percentage of ownership, and in a co-op, you're going to vote based on your shares of stock owned. It can be confusing, but a lot of owners believe that they have a different amount of vote. Again, it's based on percentage of ownership. So if you have a larger unit, you're traditionally going to have a larger percentage of ownership, and your weight bears a little more, or your vote bears more weight. Eligibility. So unless your declaration says otherwise or prescribes additional requirements, which we have seen before, typically you only need to be an owner to be on the board. So keep that in mind, making sure to know exactly what your governing documents say in them. And traditionally, there will be staggered terms, which allows for certain board members to stay on while there will be an election. So let's say you have 3 positions, one will come up every year for election, 2 will stay on. So it'll be 1-year terms versus 2-year terms.
And really the purpose for the staggered terms is so that there isn't a full turnover at any one time. It helps with the ease of transition of board members, so you will have at least one board member that has knowledge and experience that can stay on the board as a new board member comes along.
All right, so membership meetings and elections. This comes up often, you know, how are elections handled? Traditionally, there will be candidate endorsements where the board will send out a notice and will say, you know, anyone wishing to serve on the board, this is your time to, you know, put forth your name, and we will make sure that we gather the appropriate information, and then at that time, the board gathers the information, and then they will send out information to the membership prior to the annual meeting.
And just to clarify, what happens is the board will send out the nomination forms, they'll come back. Sometimes boards will send out nomination forms at the same time they send out proxies and leave some blanks. It can be done either way. A more popular form that we have found is send the nomination forms, and then once those nominations come in, you send the proxies out. One thing that has been coming up pretty frequently is candidate endorsement. Can a board member endorse a candidate to run for the board? And the Condominium Property Act says no. You need to remain neutral. So I know sometimes it can be difficult as a board member because you may find that someone in particular has the experience or the knowledge to be a really good board member and you want them to be on the board. So how do you kind of solicit for them aside from openly endorsing them? And our answer to that is proxies are the winner. So what you do is the biggest thing that we have found for successful candidates are going to be how many proxies can you go out and collect? Because typically it is very difficult to get members and to attend board meetings, election meetings. So what you need to do is really go door to door and collect your proxies so that you can ensure when you walk into that election meeting, you have enough votes to get that candidate on the board. So of course, candidates can speak for themselves. They may, have an opportunity at the board meeting or prior to the board meeting to kind of go out and campaign. But we really, really, really strongly recommend that board members do not do any kind of endorsements or campaigning for anybody running for the board, except for themselves, of course.
All right, the methods of voting, and this does come up often. I'm just going to mention it. It can be a very confusing topic, but cumulative voting, it's a method by which each member has the same number of votes as there are seats up for election. So the easiest way to describe this is if there are 3 seats up, you have 3 votes to cast, you can choose how those 3 votes are cast. You can take all 3 votes for one candidate, you can split them up among the 3, you could take 2 for one candidate and pose your last one for another candidate. So it's not really confusing, it's just a matter of understanding whether or not your community has cumulative voting. So it's either cumulative voting or non-cumulative voting, and you'll see that in your governing documents. All right, so electronic or mail-in voting. So the most important thing that I'll touch on this is that before this type of voting can take place, the board has to first adopt rules, and those rules have to be done at least 120 days in advance of the election. And this comes up very often, especially at the time of the election, and we unfortunately have to let our clients know that it's too late. So we need to deal with it in advance.
So if you recently had an election, which you probably did, and you didn't have electronic voting and you're thinking this is something that you want to implement going forward, now is a good time to be thinking about that, to get your rules and regulations developed so that you have plenty of time in advance of next year's election to get these promulgated.
There is additional information about that within these slides. All right, so a very common scenario that we unfortunately see as attorneys is challenges to elections. It does happen. People do litigate over it. And the most important thing we can tell you as board members is that the materials themselves have to be retained for at least 12 months. And they can be examined by an owner who makes a proper written request for them. And that they do have 1 year to challenge the election. And it's a touchy subject, but people do get heated over elections and not, being selected to be on the board. And they're entitled to, review the materials and take a challenge if that's, their prerogative.
And some of the challenges that we've faced in most recent elections is you may come to an election meeting with a list of owners in their respective units. So when they come in to check in, you kind of know who the owner is. They're getting one ballot and they haven't turned in a proxy. You're checking for all of that. But a lot of times on site, we can't validate a proxy or a ballot because there is a question about ownership. So sometimes there is a matter of we need to wait until after to check title to make sure that this is actually the owner, or maybe somehow our records didn't get updated. So know that that can be a challenge as well when you're actually at the election counting your proxies and counting your ballots.
And I think for us, the most important thing that we can relay to, boards and property managers alike is just to be organized. Mm-hmm. And that's really what it comes down to, is making sure that you have all the information that you believe necessary at that annual meeting to be able to move forward. All right, board meetings. So just to cover a few items that pertain to board meetings. So proper notice has to be given to all owners. It doesn't matter if it's a special meeting that's being called, an emergency meeting that's being called, you still have to get that notice out. They have to be aware that there is a board meeting to occur so that they have the ability to attend if they so choose. It does, require some democracy to occur. It requires civility. And keep in mind that the directors represent all of the owners. And for me, the most important part that I relay to my board members is to make sure that they are not making decisions that seem underhanded to the remaining owners. And by that I mean making sure that there's transparency in all decision making. And a lot of that is done by having your meeting minutes reflect exactly what actions have been taken.
Another important thing is to be prepared. More commonly, you'll find that your managers will provide you with information up front of that meeting. Make sure that you take the time before the meeting to review the materials, to review the documents, so when you actually get to the board meeting, there's some order involved so that you're not spending time reading an entire contract and then debating it amongst each other when that work could have been done up front. So you really want to kind of appear as a united front versus debating each other, because that kind of causes the owners that are maybe attending that meeting to be a little bit more anxious and weary of the decisions that are being made. So again, that's where civility comes in. And then, you have to allow for recording. One common topic that comes up is whether or not unit owners have to be allowed a time period to talk at a board meeting. The Condominium Property Act does not necessarily require that owners be allowed to talk at a board meeting. Certainly, it's something that the board can determine on its own. Usually what we recommend is just to keep the peace, to allow maybe a 5 to 10 minute time period at the end of a board meeting, so it's not disrupting your business, to allow unit owners to maybe express some grievances or bring some issues to the board, because then it kind of alleviates board members being approached in the building or on the sidewalks when they're walking their dogs. It just gives them a time to be heard, and sometimes that's all owners really want. It's just that small opportunity. And the board can always say, look, we appreciate your input, we'll give it some thought and get back to you on it.
All right, we've got a couple charts in the presentation for you pertaining to notice, the number of meetings that you're required to have, and we've defined that within these slides. All right, covering general procedure for board meetings. Robert's Rules of Order is not required, but it is generally followed by most associations. And traditionally, there's an agenda, and you have, your order of business and how it's going to be conducted. We have set forth a sample agenda within the presentation itself. We highly recommend that the board follow the agenda. Stick to it. It helps run a more efficient board meeting. And it keeps, it allows for meeting minutes to be accurate as long as you're going down the agenda format. The open meeting requirement. So all board meetings must be open to the members of the association except for that portion of the meeting which I call the executive session or closed session that is to be held for one of the 6 enumerated purposes. We have laid that out for you. So, and we'll discuss this further in the next couple slides. All right, with respect to meeting minutes for open meetings, there is a purpose behind them. The purpose is to make sure that the business of the board has been accurately reflected in writing. Traditionally, the secretary takes minutes unless that's been delegated to somebody else at the board's direction. The main reason why meeting minutes are taken is not only to reflect the actual business that's been taken, but to make sure that we have a recording of what's happened. And the most important part of that recording is that it is discoverable in litigation. So we caution our boards from having meeting minutes that are summaries of what happened or very lengthy notes as to what transpired with the discussion. Meeting minutes should be kept to exactly the board business that was transacted. The meeting minutes that are taken also need to reflect the approval of the meeting minutes from the last meeting. And sometimes that gets overlooked, so please make sure as you're following through your agenda that that gets taken care of. Otherwise, if the meeting minutes from the last meeting weren't approved, they're not part of the business records of the association. And they're not going to be able to be reviewed by owners, so it's important. Another part of parliamentary procedure, Robert's Rules of Order, is making sure that your meeting minutes have motions in them. Who made the motion, who seconded the motion, that there was discussion, and that the vote was taken by the board, and whether it was, approved unanimously or just approved.
Yes. So this is something that is new, whether or not meeting minutes should be done for closed sessions. And before a recent case that came down in 2018, it was really up to boards whether or not they were going to keep minutes in closed sessions. And actually, if you talk to professionals in the legal field, they would have told you not to keep any minutes because you really didn't want owners to know what confidential information was going to be discussed in closed sessions. But that has changed, and meeting minutes are absolutely required for closed sessions. Our recommendation, though, is to keep it simple. There's really been no guidance, though, as to what those meeting minutes should include, but what they should do is reflect the business that was done. So you really want to have just the minimum amount in there. What's the date of the meeting, the time, call to order, you had the quorum, and what was your purpose. And it should really be one of these 5 that are listed out, or 6 that are listed out in the Condominium Property Act. One thing that we have found with some of our clients is they use key systems. So for example, if you are having a closed session to talk about, collection of assessments for particular unit owners, or you're talking about violations for particular unit owners, you wouldn't want to put their name or maybe their address in the meeting minutes because those could be discoverable, and then you would be giving that information to other owners. So what you would do is create a legend with a key that kind of puts your own code to it. So you might create A, B, C, D, E, F, G as far as unit owners and create your minutes that way.
Another hot topic is emails and whether the board can circulate emails to make decisions. Merely discussing association business without making decisions does constitute board business. And doing so is deemed an unlawful meeting of the board. We've also had recent case law that talks about workshops, and they're not permitted to be closed. Polling and canvassing board members via email or other means in advance of open board meetings is not permitted. It's a hot topic. We know that it's hard to conduct business when you know, we're all busy. We have, you know, various things going on. But the most important thing is that you have to make sure that you're doing business at an open meeting. And that's really the gist of it.
So information can be passed through email. So for example, you can be given contracts to review, but as far as the discussion on the meat of that and whether or not the association is going to move forward with that, that all needs to occur in an open board meeting. So that's really the distinction there. It doesn't mean you can't have emails where you can prep in advance. It just means that discussions regarding those particular items or votes on it at all, or polling, should not happen outside of an open board meeting. Really quick, with regard to workshops, one thing that has been an issue is there are boards that have commonly in the past held what they call workshops, which is just opportunities for the board to meet to work on, you know, various items, whether that be contracts, whether it be, you know, rules or regulations. Again, it can't happen. One thing that you may be able to do is discuss meeting with your legal counsel and making them an active part of your workshops, and that would then allow you to close that session.
Delegation of authority and whether or not your board can do it. So a board can lawfully delegate authority to a manager or a commission of board members if the governing documents allow for it. So you would have to look to your declaration to see if it allows it. If it allows it, you still need to make that decision and have an approval made at a board meeting. So that way the meeting minutes accurately reflect that.
So we're going to kind of switch gears for a minute. We've kind of been focusing more on the day-to-day and what it looks like to be a board member and to hold board meetings. And what we're going to do, and you'll find that we're going to hop around just a little bit, because what we wanted to do is address some hot topics that we found to be something that more common recently than ever before, and just kind of briefly talk about what that means for you guys as board members, and give you a little introduction to these topics.
All right, so home rule legislation and the City of Chicago ordinance. So in 2018, January 1st of 2018, the Illinois Condominium Property Act was amended. The purpose of the amendment was to allow for some additional protections in terms of what type of information could be disseminated to owners when they made a request from the board. And specifically, under the law, the board was required to keep and maintain a current listing of name, addresses, email addresses, phone numbers, and the vote of all the members at their principal office, so as part of their business records. While the City of Chicago is a home rule community, and what that means is that a home rule community can enact an ordinance that is more restrictive than state law. And it's a weird nuance in Illinois that allows for it. There's not a lot of communities that are home rule, but the City of Chicago by far has its own ordinance that covers many of the topics that are addressed in state law, and it's, as long as they have it in their ordinance and it passes, it can be more restrictive. So there was some debate about, we had the Illinois Condominium Property Act that required this, and then the City of Chicago enacted an ordinance that said, no, you don't have to do it, because there was a whole lot of public uproar over it. So essentially, City of Chicago nullified Section 19, a particular provision of it. And then there was a challenge made, and as part of that challenge, there was a compromise that was reached. So the Chicago ordinance was again amended, and it allowed Chicago condominiums from being able to opt out of the nullity and not having to have that list maintained. So if 2/3 of the owners vote in favor of allowing owners' email addresses and phone numbers to be available for inspection, examination, and copying, then a condo association can keep that type of information as part of its records. But absent that vote being taken in City of Chicago, they do not need to maintain email addresses and telephone numbers for their business records and have those openly available to homeowners. And it's not just the records request part of it in a City of Chicago ordinance. There's a lot of other nuances in it. So as board members, it would be in a board's best interest to familiarize themselves with the actual City of Chicago ordinance. It's not very lengthy, but please feel free to just take a look at it. It is available on the website.
Another common hot topic is emergency action, and I can bet that a lot of boards experienced it this past week with the really, really cold weather. What happens if there's an emergency and a board has to act and there's not time to call a meeting? What do? Can the board act? And the answer is yes, but make sure that you call an open meeting shortly after you act to ratify and confirm any emergency action that's taken by the board. And another similar topic is board action between meetings. Again, board decisions need to be made at open meetings, but if there is an emergency that comes up, go ahead and make the action and then confirm it, ratify it in an open board meeting.
Giving you guys some information on the types of information that constitutes action between meetings on this slide, so you could feel free to take a look at that. Another question that comes up is budgeting and how a board is to handle an item that may not have come up originally on the budget, and whether or not it's necessary for an item that's been approved in the budget for the contract itself to be approved. And the answer to that is yes. So if you have a budgeted item for, let's say, landscaping, and then you go out and you get bids for landscaping and you get the contracts and you've decided to select one of the companies, the question has come up as to whether or not that actual contract needs to be approved, and the answer to that is yes. The board has an obligation to make sure that the information contained within that contract itself is in line with what was approved in the budget. So you do have to make sure that you approve those contracts.
The next couple of slides, we're just going to breeze through these. They talk about committees versus commissions and the difference between those and kind of what's required in most of those. So we encourage you to kind of review these slides along with your governing documents so you really have an understanding of what a committee is versus what a commission is and kind of the parameters for those as well.
All right, so the basic understanding of a committee is you have to have at least one board member on it, and the members of the committee are appointed by the board, and you have to have a quorum to establish it. I'm going to breeze through some of these for time purposes. Oops. All right. Sorry about this. Union labor. So I'm just going to touch on this topic. Typically, larger associations who have adequate resources will hire unionized labor. The most important part of union labor is to remember that there is going to be a collective bargaining agreement that those employees are going to be governed by that is separate from any employment agreement that the association may have with that particular employee. So you can't just rely on your employment agreement with that, particular employee. You have to always refer back to the collective bargaining agreement with respect to, certain issues, termination, separation, certain work restrictions, pay, overtime, those types of issues. Lots of information on union labor, so make sure that you guys take a look at the slides. Understanding the role of management. We deal with this almost daily. We want to make sure that our board members understand both what management expects of the board and what the board expects of management. Traditionally, the management is charged with implementing the actions of the board, and they partner with the board to run the business of the association or the co-op. There's a contract process in place. We enter into, there's negotiations, and you ultimately resort down to a contract, and you have to refer to that contract. When to contact legal counsel, we've given you guys, a bunch of information on here. We again strive to make sure that our clients are, adequately informed on, what their rights and responsibilities are. And sometimes the issue arises that you do need to get an attorney involved. So just know when to get the attorney involved. That's really what it comes down to. We've got some information in here about some new law that came down. It is the Illinois Ombudsperson Act. It is applicable to condominium and common interest community associations. It did require a written policy to be put in place by January 1st. If your board does not have one, please work with your property manager to make sure that you have a policy in place. And we have given you some information about what the policy needs to include. I am not going to talk a lot about collecting assessments because this is a seminar in and of itself, and I would be like hours. I could talk about it for hours. But the most important part is that an association needs to make sure that it is collecting the monies that are owed because it is essential for the operation and maintenance of the association and the common elements. If you're not collecting money, then you can't operate your business, and you are running a in some cases, it could be $1 million real estate business, and we have to treat it that way. There are, situations that arise that impact an association's ability to collect: foreclosures, bankruptcies, tax sales. There's a number of situations that come up, and we have outlined that for you in this presentation.
And really the importance of us pointing out some of these issues with foreclosures and bankruptcies is a lot of times boards have the misconception that if there's been a foreclosure or there is a pending foreclosure or bankruptcy, oh no, we just have to write that account off. That is not necessarily true. There are options available to the association to collect even when a foreclosure has been filed, and even after a judgment and a foreclosure has been entered, and the same goes for bankruptcies.
Yeah, so please review the slides, and then if there's any questions, please feel free to talk to the property manager, and we will make sure that those, particular issues get addressed to you. I have outlined some of the bankruptcy information in here. I know that seems to be a hot topic. Bankruptcies are not necessarily back on the rise, but I think when it happens, an association does need to know how to deal with it. So.
And know the difference between a Chapter 7 bankruptcy and a Chapter 13 bankruptcy, because that is really going to have an effect on what can be collected versus what can't.
All right, that's all we have for you.
Well, Kathy and Kat, thanks very much. This is Mike Porter, Regional Director from Lieberman Management. I will be your moderator during the question and answer segment. Please submit your questions using the function on your screen, or you can submit your questions through Twitter. As I understand, there is either a chat button on your screen, or perhaps if you hover over the host identifier, you will be able to chat with the host. Our first question comes to us actually through Twitter. Kathy, how do you amend a declaration? Are there if there are admin changes, are there admin changes that can be done to the declaration without the full process?
That's a really good question. So this is actually something that I'm actually dealing with right now, is going through some legal challenge. So a board has the right to correct what we call errors and omissions, which is basically correcting maybe a mistake that you would find in a declaration because something is misspelled, or it was maybe it was inadvertently included. The board has the opportunity to change that via amendment without circulating that to the unit owners and getting their approval. Other than that, any type of material change, so anything that really changes any provision of the declaration, is going to require unit owner approval. And that's when you're absolutely going to have to go through the process of getting the ownership involved and maybe potentially mortgagees as well.
Okay, great. Thank you very much. Our next question is from a participant here. Who is eligible to serve on a board when a unit is owned by a corporation or a trust?
So with that, it will be so that corporation will designate one person to serve. Traditionally, it will be the president of the corporation, and that, in a corporation, it's easy to determine who that is. So there needs to be a delegation of authority to that particular person to act as the owner.
Okay, great. Our next question comes through the participants. It's a co-op question. For a co-op, can shareholders call a special meeting?
Yes, but they will need to look to their bylaws to determine the percentage that is required to have a special meeting called. And if there is no information in the bylaws, then they will defer to the Not-for-Profit Corporation Act.
Great, thank you very much. Keeping track of time here, I think we've got time for several more questions. One of our board members does not attend all the meetings. Can they be removed?
You know, actually, that has been asked of us before. Technically, no, because there isn't a requirement in your, typically, let me say that, because there may be, but typically you will find that there is not a requirement in the declaration or the bylaws that says a board member must attend every meeting. So there isn't a provision that would allow the remaining board members or the owners to necessarily remove them on that basis. However, in our practice, there has been some discussion about maybe sitting down with that board member and talking about what a commitment means and are you truly acting as a fiduciary if you are not participating regularly in board meetings. So you have to be really careful not to assume that because somebody isn't participating that they can automatically be removed for that reason.
Fantastic. Our next question comes to us from a participant in today's webinar, and it goes to the point of a unlawful or ill-advised meeting. If there's a committee where there is a majority of board members attending that committee meeting and on that committee, does that, if they meet, does that create an unlawful meeting?
So that's a good question that I cannot give you a definitive answer on. It could be, because it depends on what that committee is meeting about. If the committee is meeting to discuss something that ultimately the board would determine, so for example, if the committee is meeting on something that the board would ultimately be determined by the board, it could be viewed as a board meeting because you have a quorum and you have a majority of the board who may be making that decision.
But if it's been delegated to that particular committee, then that decision is authorized to be made during that meeting. And then it would be, the decision would be relayed back to the board, and at the next open board meeting, that would be ratified. The decision made by that committee would be ratified in the meeting minutes.
So I guess, in other words, to be very mindful of the fact that when you do have multiple board members in attendance at a committee meeting, that you are solely there to do committee business and not turning it into anything other than that and what's been delegated to the committee.
Okay. I should note that that question was submitted with the caveat that it was a duly noticed meeting. Let me ride on that question with another participant. What items are you able to speak about in executive session?
So if one of our slides I know covers, there are specific topics that are laid out that can be discussed at closed session. One of them is
hiring, firing,
let me just go to it.
consulting with legal counsel.
Let me find it so I don't misspeak on that. But it is actually specifically set forth in the Illinois Condominium Property Act so that you don't really fall outside of that. The only, here we are. So to discuss threatened or pending litigation, so you might have a dispute that has arisen with a unit owner that isn't necessarily in litigation, you just know that it's a dispute, that can be discussed in closed session. It would be considered anticipated litigation. To discuss employment-related matters with a third party, so if you're going to talk about contractors, hiring an independent contractor, you can discuss that in a closed session. Interviewing potential employees, contractors, or agents can be done in a closed session. Discussing rule violations, violations of your declaration, that should be done and can be done in a closed session. Discussing delinquent expenses that are owed to the association, and finally, consulting with legal counsel. And what's nice about the last one, consulting with legal counsel, is it's very broad. So that really, like I said earlier in our presentation, gives the board an opportunity to bring in legal counsel when they want to have a closed session so that they can discuss something that maybe doesn't necessarily fall under one of the 5 above that.
Okay, I think we still have time for several questions here. Here's a good one. Do unit owners, for a board meeting, do unit owners have the right to videotape the board?
Yes, they do. There is a provision in the Illinois Condominium Property Act that specifically discusses the types of recording. Audio recording is permitted. There is an opportunity, I believe, to video record as well. That obviously is not the case for closed sessions because owners would not be permitted to be in a closed session.
Okay. And let me just to clarify.
Yeah.
So if a participant in the executive session would like to videotape, can they videotape?
Well, there's nothing that says they can't. We would strongly recommend that they don't.
Understood. Next question. Can a condo association force owners to participate in bulk cable contracts? I guess this is coming up in cable contract season a lot.
You can't force owners to do anything like that. Now, you may issue rules and regulations that have such requirements, but again, you're walking a really fine line in forcing owners to participate in something like that. It would be our recommendation that you really just try to sell it to the owners to participate, and why that would be so cost effective, not just for them, but for the association as a whole. I have seen, I mean, you will find in the Illinois Condominium Property Act, there are a lot of declarations. The board has the ability to enter into those contracts, but certainly no provision that would require an owner to participate in that.
Okay. Just as a caveat, they may not participate, but they will get charged for it.
Yeah.
So it's up to them if they. So can the board require that owners provide keys for emergencies, knowing that the alternative is that we'll drill out your locks?
Actually, this is really, I'm glad that this question came up because this is something that was very popular last week with the cold weather. There is nothing that would allow a board to make this a requirement. Now, they could make it a rule and regulation for their community, which would essentially say, hey, we're going to require every owner to turn in a copy of their key, and we're going to use that for emergency situations. And that can certainly pass so long as nothing in the declaration and bylaws say that they can't do something like that. And actually, this is something that may be essential to the community as a whole, especially with condominium buildings, because there's a lot of times where people will go on vacation and not leave proper contact information and not properly winterize their unit, and they're affecting the neighboring units and the common elements if there can't be access to their unit because maybe a freezing pipe that can cause water damage. So really the only way to really require it was to enact a rule and regulation, but assuming that would not conflict with your declaration of bylaws.
It's about selling it, really.
Mm-hmm.
It's about selling them that the alternative is your door is going to be broken down. It's going to cost you way more money than you just giving a key and it being safeguarded.
Right.
So.
Okay. 2 last questions is what we have time for here. First, in the minutes, do you identify members who vote against or abstain from a specific board vote or decision?
We don't necessarily recommend that you do that, because then you're singling people out that could cause trouble later on. It's better off that you just kind of keep it vague and say that a motion was made and there was a second.
Okay. Do you identify the votes at all?
No. I do not recommend identifying who voted which way. I just recommend that if there is an abstention, that you note that an abstention was made. Your meeting minutes are going to reflect who was present. So as long as the vote passes or it doesn't pass, then that's really what should be reflected. If an abstention was made, just say an abstention was made, but not necessarily by whom that abstention was made.
Oh, wow. And so you would just say the motion passed by number of votes, or just the motion passed?
Motion passed.
Great.
But putting number of votes wouldn't necessarily be wrong either. But the simpler it is, the
2 to
better.
1
Yeah.
versus, you know, Joe and Steve voted this way and Bob did not.
Gotcha. Okay. Well, I didn't know the answer to that question was going to go as long. So we're going to wrap up here. Again, I would like to thank all the participants in today's webinar. Kathy, I'm going to butcher your name a little bit here. So Kathy Chicalis Highcamper.
You got it.
I got it. All right. And Kat Formiller. I got yours. All right. Tressler, thank you very much for the very valuable information. Again, Tressler represents many buildings and co-ops here in the city of Chicago, and we thank you for your participation today. Today's webinar will be available after the live session and will be accessible through our website, again, as Jackie mentioned, liebermanmanagement.com, Lieberman Management, all one word. Everyone previously invited will be receiving a follow-up communication. Additional questions can be sent to the email address that will be included at that time. Please be sure to follow us on Twitter, Facebook, and LinkedIn. If you have any further questions regarding governance or any other association matters, you can always contact Lieberman Management Services through your regional director, property manager, or account representative. Thank you all again for participating, and I respect everyone's time. Have a good day. Bye-bye now.